सर आमर लॉ आउ इकोनॉमिक्स केमती दिजो जगह एसोसिएटेड एंड केमती इकोनॉमिक्स बाय लॉ इकोनॉमिक्स हम केमती इंप्रूव करि परिबा जेबे कि हमर इंडिया इकोनॉमिक्स रो रहया कथा माने जति के रहया कथा इकोनॉमी हमर वर्तमान पूरा बहुत खराब ही अछि लोगन को जॉब मिलुनी प्राइस हाई हेई चली छी तो सेटा हमें बाय लॉ किबा थ्रू लॉ केमती ताको मैनेज करि परिबा और से दिटा जगह केमती एसोसिएटेड
ओके दिस इज deeply connected.
So criminal case रे पुलिस रो रोल टा केमती थाए?
In a civil matter, two parties will fight. So they will fight tooth and nail because they will control their action. A party will fight against B. A will appoint his lawyer. B will appoint his lawyer. A party will have his own document. B party will have his own document. So they will be both of them will be controlling their own interests.
नमस्कार आपन को स्वागत करूची अनस्क्रिप्टेड विथ प्रीति. आज हम संगरे जे अछंती से जड़े बहुत बड़ लॉयर आम किंतु आज तक लॉ विषय रे कौन अच्छी नियम कानून पढ़ाया को चाहूनु नुआ जेनेरेशन आउ लॉ रो एक्चुअल उपयोग पाई कौन करी हबो सेटा सर हमको बहुत भल से बुझेबे. आसंतु तांको स्वागत करबा संस्टार टीवी को. सर नमस्कार भल अछंती?
Absolutely. Thank you so much for inviting me.
थैंक यू सर आपण हमको टाइम देथिबारो. आमे तो वकील वकीलाती ए सब जिंस विषय बहुत किछि जानि छु किछि जानि ना हो किंतु आपण जने एमती पर्सनालिटी आमे जहा जानिलु जे आपण आज पर्यंत केस हारी नाहंती. वकील मानकर काम हैला से माने केस नेबे किछि जितिबे किछि हारिबे किंतु आपणकर गोटे मोटो हैला किंबा आपणकर सेटा एम भी हेथै पारे जे आज पर्यंत आपण किछि केस हारी नाहंती. आपण बहुत एजुकेटेड लाइक आपण केमिस्ट्री रे साइंस रे पढिचंती ऑनर्स नै कि ग्रेजुएशन करचंती देन यू हैव डन योर सीए सीएस एंड यू आर वर्किंग इन IBS. देन आपण केमती लॉ को केमती आसिले आउ केमती कोन तार चिंताधाराटा आपण आसिला टिके हमको बतेबे.
First let me correct you first. Priti, the first thing is that yes, ultimately I have won all the matter. And at the first instance, my always effort is that, first of all, whatever the kind of matter that will come to me, I have one simple principle. If somebody is knocking my door and I will meet him, then the first thing I want to evaluate whether he is genuinely aggrieved or not. If he is genuinely aggrieved, then I say there is a redressal. That is what we call it as a justice. So redressal jadi janakara na hobo society re, that will always leave a blot in the system and the society. And as a important member of the society and a profession like law, a noble profession, I always believe it is my responsibility to see that the people come to my door gets justice. And if somebody comes to my office and he is not deserving some relief, I politely tell him the reason and I say that it is worth not pursuing it because you are not deserving a lawful justice. So that is how I always believed. And winning or losing is always a matter of error or no error, because law, what is law to me cannot be unlawful to you. And I do not believe in the idea that law is a subject of interpretation. Yes, it is a subject of interpretation in the sense that you will read it and you want to understand it. Then you have to form an opinion on this. But does it mean that left hand side for me is left hand side and right hand side for you is the right hand side? If it is not, then how come a law means different outcome to different people for the same set of facts? That's something initially bothered me a lot. Over a period of time, I really did a lot of R&D. I'm a thinking lawyer, I believe. And I am a justice-oriented lawyer in the sense that before it, of course, we all know that justice is given by the honorable judges, the courts. But who will guide them? Who will assist them? It's our duty. A small error here and there, output will change. Like thank God I'm from a science background and I have that analytical mind. And I say that input is equal to output. Now, input can be a set of facts, a set of law. What is set of facts? means for a particular cause of action. Suppose you are aggrieved of something. For that, a unique set of facts is there. If the client is telling you the unique set of facts, then it is our responsibility to bring the unique set of governing law for that set of facts. Means a finite set of facts combined with a finite set of law is the input, and they are finite by themselves in that combination. So when it goes through the process of adjudication, there has to be only one outcome. And I refuse to believe, and believe me, Preeti, I really in fact invite all the people to practice this style. It's extremely empowering, and it is also very less burdensome for the institutions. So began from a journey from chemistry honors, entered into this non-science subject like accounts, like CA, CFA, CSA, CS. I was briefly there in a job in IBS, but I didn't like it because it was academic line.
But you chose your profession as a lawyer.
Correct.
What makes you that to choose that profession?
In fact, I was very impatient. I'm a very free-minded person, and I was teaching and twice the age of mine that point in time in 2002 and 2003. So I was always looking to for a brief period I liked that because I love talking, explaining. But over a period of time, I realized that perhaps this is not the subject for me. I mean, or the career for me, because I know in academics there is a limitation.
Yes, sir.
And my mind is always a free mind. Always, it never wants to remain within any kind of bounds. So I got an offer from Delhi. I was in the Hyderabad. I was invited there. I went there for an interview, and because of this qualification, I asked for a very exorbitant salary, which of course didn't materialize. But I met the one great jurist, Didi Durga Das Thakur, who is the father of Justice Tirath Thakur, who was the Chief Justice of India in 2014. So, in my interaction with him, he in fact guided, goaded, and suggested me, strongly recommended me, that you should be in the law profession. After knowing my analytical approach and all, because we used to talk for a number of days and all, because he was admitted in the AIMS, All India Institute of Medical Science, Delhi. And that interaction led to, because he used to tell me a lot of beautiful stories about the lawyers, and more importantly, my cousin brother, whose name is Ganesh Chandra Kanungo. They are big in Odisha, as one of the biggest contractors and all. So they used to have a very big cases in Supreme Court. They would wait for a 15 days, 20 days to get an appointment with the senior lawyers then.
Yes, yes.
And Didi Thakur himself was the Chief Justice of Jammu and Kashmir. He was also the governor. He was also the minister in the Union Cabinet. So he was a very tall personality. And both of these people, I give credit to both of them for infusing interest, and more so, meeting my expectations, and that led to my entering into the profession, and that is how the rest is history.
Thank you so much, sir, for that, for telling us that how you become a lawyer. Then what message you would give to the next generation who are doing law and will be the lawyers? Because there are so many myths and truths are there. What your suggestion or your interpretation about law for the next generation? Can you please tell that?
Well, I am a first generation lawyer. My father, none of our family members were into law. Though my maternal grandfather, who was a lawyer then, but then I've never met him. By the time I was born, he's not there.
Can anybody be a good lawyer?
Well, what is again is a subject of what is good or bad. It is very subjective, I'll tell you. First of all, coming from my background, without having any legal background, I succeeded in this profession. I believe I have succeeded. And contrary to the myth, I call it as a myth, like when I meet a lot of students come to my office for internship and they join me as my associates and all, they say that the first generation lawyers, it's very difficult. I say that it is rather better. How? Suppose a big lawyer's son or a judge's son is practicing. There is always a baggage he carries because he is always compared with the legacy that his parents or his cousin, that they are into profession. So the people will always evaluate that person on the basis of their legacy. So you are always under constant accountability and evaluation. Contrary to that, we didn't have it. I didn't have it. And to the extent, I must tell you, I've never worked under anybody. Because I came to Delhi for an interview. It didn't materialize, and then I was suggested to enter into law, and I just sent my resignation from there. I never even returned to Hyderabad to collect my belongings also. Threw everything and entered into it. And hardly into 45 days of my profession, enrollment, I got my first assignment then at 1.5 lakh.
In 2003.
That is my first assignment. And I converted a criminal matter into a corporate matter. A criminal prosecution was going on. A lawyer with whom I was, briefly associated in a very informal manner. He's a criminal law giant. His name is Janakalyan Das. So I was going to his chamber, trying to understand, evaluate it and all. And I saw that one file he is dealing with a company prosecution matter. So I said that I can give a better idea than this. And this prosecution was going on for 5-6 years by that time. I said that I can finish it within 3 months. And what did I do? That company was defunct. So what I did is that 561 Companies Act 1956, Section 560, I close that company. This is called the closure of the company. The lawyer would not know. That practicing lawyer would not know. Yes. Because he was a criminal law expert. Yes. Since I had that, knack of corporate law understanding. So I suggested, client agreed, and it happened, and they paid me that amount of money. So I have a suggestion to the next generation of the students. They should have a range of law at their disposal. And my qualification gave me that range because we were so badly, toiled to qualify these tough courses, professional courses in India, and I always used to study not exam-centric. It is complete. I will start A, finish at J. And that helped me in continuing the profession. And all my friends, because started in Supreme Court, so all of my friends then got to know that I'm having a exposure on the taxation laws, commercial laws, a lot of laws I used to know that point in time. Say they would come and take the advices. And I also, a lot of senior lawyers also take opinion from me. And that is how my journey began. And if I could do it, why could not other, next generation would be able to do? I think they can do it. No problem. It's just that they believe that at another angle. The people think, the lawyers think, or rather the students think that what is theory and practice is different. This is so rampantly understood by people. I say this is a myth. Why? In courts, nothing works beyond the statute, language. Generally, we have a habit of asking the clerk, बताओ फाइलिंग इसमें कैसा होगा ये कैसा, but they would not read the book bare provision. They would take the hearsay information. So that lead to likely error, because the person who tells you something, if he is committing a mistake, then that mistake you are carrying. So initial days I used to have a lot of fight with the registrar level, officers there in courts, in Supreme Court, in High Court, Delhi High Court. They would say that this is a defect. I said, no, this is not defect. Then I will show them the provision, bare provision. Then that is how I used to debate before I get into the court, main arena to argue. I began my argument in the registry level at the defect stage. Yes. So that gave me the range, confidence. So students must know it is a myth that that the theory and the practice is different. Absolutely not. A. B. First generation lawyers cannot succeed is again another myth. I am the perfect example, and many of my friends are successful. Third, and by the way, we are earning better than the other, second, third, fourth generation of the lawyers. And the third is the godfather. I didn't have any. And in fact, I'm married to a family where the judge and the ministers are there. On the contrary, it worked against me. Any person they would refer, they would expect us to do it for free. So I ended up paying them money or spending on them. So it's never rather, जैसे बोलते हैं ना, दूरो पहाड़ सुंदर दिखे. So grass on the other side of the river is greener.
सर आमर लॉ आउ इकोनॉमिक्स केमती दिज जगह एसोसिएटेड एंड केमती इकोनॉमिक्स बाय लॉ इकोनॉमिक्स को केमती इंप्रूव करि परिबा जेबे कि हमर इंडिया रे इकोनॉमिक्स रो रहया कथा माने जति कि रहया कथा इकोनॉमी हमर वर्तमान पूरा बहुत खराब ही अछि लोकन को जॉब मिलुनी प्राइस हाई हेई चली छि तो सेटा हमें बाय लॉ किबा थ्रू लॉ केमती ताको मैनेज करि परिबा और से दिटा जगह केमती एसोसिएटेड.
ओके, दिस इज deeply connected. Let me tell you, those who have studied the management, there is a subject called the risk management.
Risk management, yes.
In the risk management, be that portfolio or otherwise, in risk management, they are taught to mitigate the risks. That is how the managers are taught to manage their business. In risk management, there are two classes of risks. One is extrinsic risk, means uncontrollable risk. What is extrinsic risk? Extrinsic risk means those are the risks which beyond your control, external to your territory, to your office, to your business. And the second class of risk is intrinsic risk, which is controllable risk, like internal management risks, where you can control, like finance, marketing, right? Some of the components are regulatory, some of the components are controllable, some of the components are uncontrollable. So, for those classes of risk which are uncontrollable or extrinsic, managers are taught that don't invest your resources in that, because in any case you don't control it. So why do you waste your resources, right?
Yes.
And world over, the managers are taught a regulatory risk is an extrinsic risk, means it is beyond your control, so don't control it. You may have to deal with it, but don't try to control it, because you don't know how to control it. It is uncontrollable, because it is a game of chance. Apparently they treat the law as a game of chance or a lottery. And if you see, looking into the Indian regulatory system and the economic factors, commerce factors and business environment, according to my estimation, it is about 95% of the entire business risk is a regulatory risk. In other words, the super majority portion of the risks of any business today is a regulatory risk. So ask any entrepreneurs and business person, they will tell you the regulatory risk in India is very, very difficult to handle. And that is why very recently of late you must have seen many corporates houses, they went under the hammer of the insolvency bankruptcy code and all. And I call it as a unable to control the regulation, thereby they went into the insolvency proceeding or liquidation proceeding. So put together all this, economy as we know is a sum total of the entire activity of the country, population, that's the economy. Now in that activity, we all are acting, but the output and productivity is not there because of the regulatory constraints. In other words, I am moving 10 steps, that's my action, and I must get a yield of proportionate to 10 steps, but I am actually getting 1 step yield. Then where is that 9-step yield is going? It's called 10 step forward, 9 step backward. Like am Odia re kuha jaye, godora kode jete mari sete.
Okay.
So our entrepreneurs, our business houses are actually working so hard, yet they are not getting the desired yield. And that has a bearing on the sum total of economy. So it sums up. The same thing, what is a reflection of a business house is facing difficulty is actually cumulatively is nothing but sum total in the form of economy. So there are capacity is already there. Employment is not there because the capacity is not operating at its full force. So means it is not that we are lacking the resources. We have all the resources. We have the best of the human resource. We have the finance. There are three resources which is important for any business to succeed. One, human, finance, and material resources. We have all. Then why we're not growing at that rate? It's only because we have a huge breakers, speed breakers. That's called the regulatory risk. And in India, this is because we treat the law as a subject of interpretation, and we treat it as if it is a matter of lottery, a game of chance. That's not the case. But therefore, I see that I always believe that it is the responsibility of the lawyers. Institution of judiciary is driven, assisted by the lawyers. Because as we know, the institution of judiciary is abysmally low in infrastructure. Be it the number of judges, be it the physical infrastructure, be it intellectual infrastructure, right? Whereas we have a 1.5 billion population, imagine. Now, with the growing economy, everybody is becoming empowered. They're realizing and they are getting aware about their rights. What is their rights, what is their duties, what are their responsibilities.
Is the economy really growing?
No, our economy is absolutely not growing. According to me, it is a negative rather. No, it is not even the snail's pace. It is actually in the negative. So,
the youths are jobless.
yes.
There are no scope for the entrepreneurs to to start up, and they are not. They have not patience and also not that much money that they can spend 2 or 3 years after that, and they get failure. So then, how can we say that our economy is growing?
Actually, the government is trying a lot. Honestly speaking, we have a MSME program.
Yes.
Micro, small, medium enterprise program. There is a statute also. The government is also trying to pump in huge amount of resources. The government has a lot of, they have a woman intention, no doubt about that. The point is, so even if their best of the intentions are not yielding the result because we are yet to find out the reason. I means no words, I say that our governance is abysmally poor. And this is mostly due to the law. Believe me.
Yes.
Due to the law. As I told you, total business risk, composition 95 is the regulatory means. Governance also, 95% of its governance concept is linked to the law. So, what kind of a policy, both executive and legislation policy that we bring in A. B. What kind of a administrative enforcement, compliance, these are also play a very, very major role. So, for example, a company is lacking the liquidity at the nick of the time. Imagine. Then it is a vicious cycle. You have the fund. It is not in a solvent state. Temporary liquidity problem is there. And mostly they are driven by the law. Or for that matter, you have the capacity of the plant. You are supposed to sell the products and get the revenues and all and keep it running. But the injunction, impediment through law, clearances and then compliances, and there is a unnecessary, harassment in the form of litigations, prosecutions, and when the entrepreneur is discouraged with this kind of a multiple layers of problem, how do you expect that they will give you the best out of them? You won't believe it, for every subject, if you see, there are more than 5, 7, 8 laws are overlapping with each other.
Yes, yes.
Now, even the professionals are unable to unclutter it, unable to understand it. They even don't know where the cluttering happening. So how do you expect them to unclutter it? Unless you are able to see it, you don't get to unclutter it, right? So our professionals are also lacking because they are also overburdened. Our courts are also getting not able to solve the problem, because I call it as a surgical strike from the legislature and the executive. Not that they have deliberately done it. What is the surgical strike by the executive and legislature? See, every now and then they're bringing in the law, which is in the form of a copy paste.
Yes.
The concept of the copy paste is one of the biggest reasons why this country is suffering so badly, but nobody is looking at it. Every now and then, the parliament and the state assemblies are used just like that. Old law ko copy karo, paste karo, aap legislation nikalo. But they don't understand what is the implication of this. For a small example, there is a problem. You are fighting a case in the court. Now, the moment that problem goes to the court will then refer to the provisions of law. Suppose same provision, like for example, say Income Tax Act. There is an old law, there is a new law. Both of them are a copy paste of the same thing. Only thing is that the number gets changed. Now, the debate will happen in the court that which section will be applicable for the same nature of action or inaction.
Yes, sir.
That means the court is consuming its time on an unproductive element. It should have actually dealt with the merit of the matter rather than discussing, acha, your offense is with respect to which section, then they will consume half an hour. There are a number of judgments under the old sections, so you will have to then say that which judgment will be applicable to the new cases and all. So, is this not avoidable? Should the court's time be not spared
Yes.
from discussing on something which is absolutely unnecessary? If at all you are making a law, it's my only appeal to the legislatures and the policymakers of this country. Be scientific at least. Spend your time 2 years at least in doing the R&D. If you are bringing a law on a subject which is already occupied in elsewhere, try to understand the new law which you are bringing in, how this law is having implications on other laws also. Because every subject there are 5, 6, 7 legislations interplaying with each other like a spider's web. Now the time has come to avoid this copy-paste concept governance. Stop making the law on the copy-paste. If you are bringing a new law on the tax, income tax, then you should do a 2 years research, complete research on a scientific scale. Make it minimalistic. Make it 60-page section, 60-page law. Is it possible? Yes, it is possible. First of all, you understand it is possible. Then only you will start working on this. You say that you want to bring a new law, 1961, you brought in a 2025, copy-pasting the same thing, just changing the sections here and there. The number gets changed, everything textually remains same. Is this not a burden on the professionals?
Sure.
Is it not a burden on the litigant? Is it not a burden on the institution? Is it not a burden on the politicians, bureaucrats, everybody? They are completely in oblivion of this idea because nobody wants to go to everybody wants to go to the heaven, but nobody wants to die.
Yes.
That's precisely the problem in our system. That is killing. Our economy is impacted because of this. I'm sure the youngsters we have, the kind of youngsters we have, the demographic advantage our Honorable Prime Minister says. But the point is, are you giving them the ecosystem for them to grow like a lion? No. You are giving 1,000 speed breakers. And top of that, you say that the law is a khichdi.
Yes.
Law is a mathematics. It's just that you should start, you should understand to be able to realize it.
How law is mathematics? Can you please elaborate? That's your funda actually to go to the court and...
Very simple.
Yes.
Very simple.
Then how can we justify it?
All right. What is left hand side to me?
It's
Is
right
left
for
hand
me.
side for you?
No.
It has to be. For me, left hand side. The same also is true to you. The same is also true to everybody. Left hand side is universally truth, right?
Yes. But
Law says-
when we come front to front, your left hand side is...
That's all right. Whichever direction you go, but the left hand side is always remains there.
Yes.
That's the law, right?
Yes.
Because if you come from the front and if it is for you is the right hand side, then we'll collide.
Yes.
Left hand side, that is how the system is. What is law? Law is nothing but a set of rules which keeps people in orderly state. Means it is meant to be predictable. If it is not predictable, then what is the difference between the jungle Raj and the civil Raj? Our very civil system is premised on the concepts of law. Law means people will follow it and it is always universal for everybody. It is truth to everybody and it is always predictable. The very idea of civilization is based on predictability.
Let law with mathematics. Can you please elaborate that?
I'll tell you. First of all, understand what is the concept of mathematics. Mathematics is called a branch of subject where concepts of predictability is writ large in it. Because 1 plus 1 means universally it will remain 2 for everybody.
Yes.
Right? Same way, law is also a concept premised on this principle that it will always be
Same.
universally same for everybody. Otherwise, we would not have changed from a jungle system to civil system. The first premise is this.
Yes.
Jungle Raj, might is right. कुछ भी कर सकता है. But that is not the concept in the civil system.
Civilization.
In civilization, civility premised on the concepts of predictability, there is the orderly elements, right?
Yes.
So law is synonymous with the orderly elements. That's what I link is with that of the mathematics.
Yes.
And as I told you earlier also, input is like in mathematics. Input is equal to output. Like if you give 1 plus 1 is equal to 2. So input, there is a set of two facts, 1 and 1. You are adding them, summation of these two factors leading to an output that is 2. This is also true in the law. That is precisely the reason why the 1.5 billion population or 8 billion population of the world is being run. Otherwise, it is chaotic for everybody.
Yes.
Right? It will be like atomic, the travel of the neutron and protons. I mean, they also follow the path in an orderly element. That is why we call it the science physics, quantum physics.
Yes.
So my point is, law is actually mathematics in the sense that it is always predictable. But that predictability means the output as a predictability depends upon the input. Now, input means the two elements work together to get the output, like a set of facts of yours, unique to you.
So, criminal case re पुलिस रो रोल टा केमती थाए काहे ना आमे गोटे जस्ट देखिले गोटे आरुषि तलवार रो गोटे मर्डर हेइथला जोतरे कि तार केस सॉल्व ही परलानी जते बड़ लॉयर हेले जहा भी हेले तो पुलिस रो रिस्पांसिबिलिटी टा केते इंपोर्टेंस रखे एक्चुअली गोटे गिल्टी गोटे लोक को गिल्टी करिया पे किबा फ्री करिया पे.
In a civil matter, two parties will fight. So they will fight tooth and nail because they will control their outcome. A party will fight against B. A will appoint his lawyer. B will appoint his lawyer. A party will have his own document. B party will have his document. So they will be, both of them will be controlling their own interest. Mm-hmm. Unlike in criminal matter is what? Now it is an offense against the state. So therefore, the victim will not appoint a lawyer. It's the state who will appoint a lawyer. So therefore, a third party comes in. The moment there is a third party comes in, the level of intensity goes down. ଆପଣ ନିଜ କେସଟାକୁ ଯେତେ honestly and sincerely କରିବେ ଗୋଟେ third party presentation କେମିତି ହେବ? Right? So same way, the police is an agency which, or enforcement agencies, they will undertake an investigation to unearth the facts. If it is a documentary offense, there are documents available. You don't need investigation. But if they are intangible offense like a rape, murder, these are the intangible offense. Mm-hmm. You need evidence. Now, it depends upon the quality of the investigation. Quality of investigator means competency. Right?
Yes. The government lawyers are really avoiding or not doing their work properly.
You see, even the evidence may not. You see, the lawyer will come in picture when there is a evidence is there. If the evidence is not collected properly, or shoddy investigation was done, inadequate investigation is done. So based on the evidence, the police will be navigating.
Yes.
So police will give that evidence. Prosecutor, the lawyers will navigate on that. If the evidence is not adequately collected, so what do you expect the government prosecutor will run on? So it is always a problem in our country that police is having huge power, but police is really not doing their job properly. Besides, the nature of the offences has gone completely. Our CRPC was 1973, which is an identical provision of 1800 CRPC, and the BNSS, which has come as a new law, Bharatiya Nyaya Sakshya Samhita 2023. That law is nothing but CRPC's copy replica. So that means, in other words, even though we call it as a 2023 law, but it is actually 1800 law.
लॉयर मान भितर अकाउंटेबिलिटी कमी रोचे कि कारण जी हिसाब से कारण पैसा लोभर प्राय सबू लॉयर जेकोसी क्लाइंट आसिले क्या फेरांदी जे नाई मु करदेवी किंतु से पुणी सेठी हारे कि नेक्स्ट आउ गोटे कोर्ट को जी सेठी भी हारे तो लोक मान गोटे पैसा एक्सट्राक्ट कर गोटे गोटे फर्मुला हो जाइए कि निज प्रति निज बिजनेस निज प्रोफेशन प्रति से रहुनी से जी रहा कथा इंटेंशन कि भल इंटेंशन से लोक हैरान कर ना कौन जोटा आम कह लॉ ऑफ अकाउंट लैक ऑफ अकाउंटेबिलिटी आज्ञा
There is a huge systemic problem we have. It is not only the problem with the lawyers, it is also problem with the litigants. There is a lack of information, transparency, and there is also a lack of medium to evaluate lawyers. And economic status. These all contribute to this problem. It is not a one factor centric problem. Accountability, like for example, as I tell you, when I take a case, I evaluate 100%, 360 degree, and for that also, I ask for a fee to tell that whether I can win or I cannot, whether a particular deserving outcome is possible or not. I need a thorough examination. It cannot be shallow. It has to be 360 degree and 100%. Right? For that, you need a lot of resources.
Yes.
But when it comes to a litigant, he would expect you to tell it just like that. Because he doesn't want to spend that amount of money. He says that, okay, after you read it and form your opinion, suppose you don't want to take it. Because you say that, I am not going to win it, or a deserving outcome is not possible. Then you will not take my case, say I will be losing that amount of money. But he doesn't realize it amounts to actually saving his huge amount of time. He would have run after the mirage for a decade or a two, hoping that someday he will get a outcome which is not legally plausible. So we do not have an ecosystem for the purpose of also to educate the litigant that you don't have to continue litigating endlessly without knowing. So there has to be an information. So there is no incentive for the lawyers also. For example, a new lawyer is coming in, he doesn't have a brief. He is being forced, tempted to take all kinds of, all and sundry matters. There is no incentive for him to say no. And top of that, our bar council, it has its guidelines saying that, and many lawyers would tell you that they would say that no, we are being told that we cannot refuse any case, without realizing that that doesn't mean that is something which you can't win. You can't keep continuing burdening the courts, extract money from this the aggrieved, and that is an exploitation also.
Yes.
And they are also losing faith and the trust in the institution as a whole. A 100-year-old law is being foisted on us, saying that, oh, you cannot refuse to take up. But that is not the meaning of the language. I have also read it. I am also telling them, I am also doing all kinds of efforts to form an opinion and then say that, no, for this reason I cannot win it. Please, why you unnecessarily pursue and burden the system? And why do I have to take a matter which I know that I can't win? Because I have also a limitation of 24 hours. But I am able to do it because I have a range of matters. Imagine I would not have, a brief at all.
Yes.
And I'm a hungry man. I have to fill my belly.
Yes.
Perhaps today's ethical elements which I'm talking about, maybe, I don't know. But yes, it is a temperamental issue. Different person behave differently at different time.
Yes.
I will not change that. I can say this in that difficult time also, but I don't expect everybody to do that.
Yes.
So it is not a professional centric. It is a whole host of issues. And a lawyer is consuming huge amount of time because of also the number of legislations where, as I told you, 8 issue, 6 laws are applicable to it.
Yes.
And there are spider's web, one element attached somewhere else. How do you do that unless you do that kind of a deep reading and understanding research? You can't otherwise do it in a shallow manner.
Yes.
Do you have that range? Whether a client gives you that option? But they don't want. They say that, okay, I want a result. So it's a problem from all sides. We need a complete clean slate approach now. Legislation, practice, jurisprudence, concepts, every way we can change it. It's possible. I'm willing. I mean, like when income tax came in the 2025, I told few industrialists saying that a 819, can you imagine? 816 sections Income Tax Act 1961, 816, and the rules together they're running into 2000 pages.
2000 pages.
Yeah. Now imagine.
And you have to read all those.
Nobody reads it. But that's the very irony. If you don't read it, you don't understand the interplay.
Yes.
You may appear to be only 2-3 sections is good enough for you, but there would be possibility that some of the other elements which you are missing out. That's where you don't achieve the 360 degree. Therefore, you leave it to Gram Bharose.
Yes.
So, I suggested that why don't India will have an income tax as a completely new concept of income tax in 60 sections. Possible. And I am looking forward to designing these kind of laws, next generation of laws. And I am telling you, these are game changer. This is just possible. It's just that people should be alighted to this possibility, and the policymakers should come in. And the problem is that if you go to the government, penny wise pound foolish. They would not reward your money because there are, before the government, all the people are available for free. But there is nothing called free lunch, right?
Yes.
So that is exactly the reason of all malgovernance. So a person like me, I've never worked for the government, not because I don't want to, but I know that they would not be able to afford me or value me. That doesn't mean that I don't respect my country. I don't. My heart always bleeds for it, you can see that. I've developed the concepts.
Yes.
It is for the larger public interest. I call it as a micro action, macro impact. Means, individual case, I'll drive. I'll get the result anyway for that matter. But the driving would be for a far larger macro impact. It will create, tranquility in the jurisprudence and scale. Means, one driven action with a multifaceted effect. That's my contribution to the system and society. Even if I'm not being engaged by the government, so be it. But individually, I'm able to do it. And that perhaps is my contribution to the system and the society. And for your information, I must tell you that all these cases that I've handled, I try to finish at one stroke. Means at one forum. Yes. All my endeavors are there to make it so simple.
And you make it in the High Court or in Supreme Court?
Because High Court, sometimes High Court is appellate court, sometimes High Court is a read court, which is the original side court, sometimes, mostly I appear in the High Courts and the Supreme Court. And of course, a lot of tribunals and all. And trial court, when there is a matter which requires intricate questions, which I have invented something, jurisprudentially, I give it to my colleagues, otherwise I also go for argument sometimes. But I have no hesitation in appearing in any particular court. I don't have fixation on anything. As a lawyer, we are the servant of our courts. So any courts should not be a problem for us. At the end of the day, the result is dependent upon the error at the first stage. If at the first stage an error creeps in, it has a far-reaching consequences. So by and large, my always endeavor has been to take up the threshold stage, at the beginning stage. that makes that case errorless, and predictability comes from there.
It's really good to know about the things that we have discussed, that the problems and the real solutions must you have tell us. And then let's wind up the session. Thank you so much, sir. आमे बहुत कथा आपन जानिलु. आमे चाहूछु आपन भी जो जिंस जाक कहिले सेटा केमती इंप्लीमेंट हबा एटा आपन बहुत भल से जानि छंती, ताको भी आपन इंप्लीमेंट करंतु. थैंक यू सो मच फॉर विथ अस.
Thank you.
नमस्कार.